Please be seated. We're ready for argument in 2378, Harley Channelview Properties against Harley Marine Golf.
May it please the court, Mr. Gunn and Mr. Smith will present argument for the petitioners. Mr. Abrams will present argument for the amicus. Petitioners have reserved 5 minutes for rebuttal. Mr. Smith will open first with the first 10 minutes, and Mr. Gunn will present the rebuttal.
Good morning, Your Honors, and may it please the court. Our client was ordered to convey its real property in just 30 days prior to a final judgment. The Court of Appeals held that the order was too extreme to be an appealable temporary injunction and therefore dismissed the appeal. In the process, it sidestepped this court's decision 20 years ago in Quest, even while relying on the very aloe vera line of cases that Quest repudiated. We ask for an opinion that does 3 things. First, we ask this court to reaffirm the test from Quest, which defines what a temporary injunction is. Second, we ask this court to emphatically disapprove of aloe vera and of its modern progeny, lest history repeat itself again. And third, we acknowledge that there can be a line drawing problem, say with other preliminary interlocutory orders, discovery orders, and so forth. And we ask this court to draw a line between procedural rulings and rulings that govern conduct that touches on the merits, which this order exactly is. Now, when we come to Quest, this court said what an appealable temporary injunction is. And in that case, the court held that because the trial court's order placed restrictions on the party and the order was made immediately effective prior to final judgment, it was in substance an appealable temporary injunction.
So wouldn't that mean, let's say in a divorce context, if a court awarded one of the spouses occupancy of the marital home, are you saying that, because that seems to fit that same definition, and that would be appealable on an interlocutory basis?
Barring some of the unique rules, Your Honor, that apply in the family law context, that would fall squarely within the definition in Quest. And
that seems like a problem.
Yeah, that's a problem.
well, if we look at the history of the interlocutory appeal statute from 1907 forward, we see this court routinely exercising jurisdiction over orders such as this that touch on the merits and that compel sometimes irreversible acts. There is the 1930s decision in DeBell where this court refused the writ involving an injunction, a temporary mandatory injunction is what this court called it, where the trial court had ordered the delivery of a deed, delivery being the final element of a conveyance. That's exactly what is at issue here. And this court, rather than dismissing the writ for want of jurisdiction, this court refused the writ, adopting the Court of Appeals holding as its own, saying that was error, that was erroneous.
Well, maybe you can think about whether there's a limit on your rule that would exclude temporary orders.
Well, there's also a historical component, and if we look at history, the difference between, say, TROs and temporary injunctions, that there's always been an element of looking at how has history categorized certain rules, and you have the equitable jurisdiction of the court, the definition of an injunction turning on an equitable order that touches on the merits and that directs the party's conduct versus more legal determinations in the court's exercise of its authority, discovery orders, so on and so forth.
But I think he was asking about temporary orders, which is really
in the family law context.
Yes, Your Honor. And
it's fine. You don't need to say anything else about it now in response to my question anyway, but you might give that some thought.
Thank you, Your Honor.
Is this irreversible?
It will have certain irreversible consequences. because the status of our client, Harley Channelview, is a single-purpose entity, and it uses the rent that the other side is paying month by month to pay the mortgage on the property. And if that revenue stream dries up, it drives them into default on the mortgage, those consequences are irreversible. And the trial court's order compels delivery of the property free and clear of all liens. There's nothing to prevent the other side from taking the property and sell it to someone else. There's no guarantee of recovering it in the end. Regardless, the order is nearly identical to the order that was issued in DeBell over 70 years ago. No material distinction. We stand on DeBell, we stand on Quest, we stand on the court's exercise of jurisdiction in those cases. Recently, last week, HMG injected this new idea that, oh, if an order is one and done, if it compels a one-time act, then it's uniquely off limits to appellate review because it's so burdensome, it doesn't deserve appellate scrutiny. That is
I thought they said it could be reviewed by mandamus.
Your Honor, as we've seen in this case, mandamus is a far inferior remedy to the right to an appeal where you have the right to written reasons, where it's not purely discretionary, and where the Court of Appeals actually has to engage with the reasons that were given by the trial court in reaching a ruling.
Could you have made the judgment final and appealable by seeking a severance?
That is conceivable, but the appealability of a temporary injunction has never hinged on the trial court's discretion in whether or not to sever a case. We shouldn't be stuck in depending on discretion. And in fact, HMG did seek a severance of this order, which the trial court, I believe, has just sat on. And so appealability should not depend on this sort of discretionary decision-making by the trial judge. We have a right to appellate review of burdensome orders like this.
If we thought that mandamus really was, and just hypothetically, the right way to go in circumstances like this, despite the different standard of review and the limitation on fact development or challenges to them, et cetera, you haven't brought us that. Can we treat the petition as, in the alternative, a petition for writ of mandamus? And do you ask us to do that in the alternative?
The court certainly has discretion to do so. If the court would like to treat it as such, we ask the court to do so. If the court would like us to supplement with a mandamus petition.
Why didn't you file that?
I'm sorry, Your
Why
Honor?
didn't you file it as that?
Because we had a Court of Appeals opinion that was facially inconsistent with this court's decision in Quest. Instead of discussing Quest, it discussed the Alavera line of cases that Quest repudiated. And so seeing an order that was facially contradictory with the reasoning of Quest, we thought we're entitled to pursue the same relief that the petitioner in Quest sought. And
If a suit is filed seeking declaratory and injunctive relief, just a standard declaration that I'm the one who's entitled to whatever, access to this cash account, and injunctive relief giving me access, requiring the defendant to give me the account numbers and passwords to get access to the cash. And we have a full-blown trial. And at the end of even jury trial, and the jury agrees with me, and based on the verdict, the judge enters an order granting that injunctive relief, but it's not final because the judge wants to think more about attorney's fees under Chapter 37 or something. Would that be a temporary injunction from which you could appeal? Is that distinguishable in any way from your case?
it would be an appealable temporary injunction, Your Honor. The mere fact that something has been decided on the merits, like after a trial with other claims still lingering, that doesn't immunize it from review.
And also the mere fact that the relief itself is effectively permanent as opposed to temporary, that doesn't change it either?
That was the precise lesson of Quest, that the mere fact that it may have permanent consequences that outlive the final judgment does not make it off limits from review.
Well, ordinarily, those orders take effect on final judgment, and so is that the distinguishing feature that in the order, in Justice Boyd's example, it's saying comply right now, not at final judgment when you would have an opportunity to file a supersedious bond?
Yes, Justice Busby, that's what makes it an interlocutory temporary injunction, because it's immediately enforceable.
Are all interlocutory injunctions temporary? I think your brief essentially says that they were treated as synonymous
Yes.
early in our legal history.
Yes, Your Honor, that's correct. That's the lesson of DeBell, the lesson of Quest, and all the cases in between.
So if it's interlocutory, if all interlocutory injunctions are temporary injunctions subject to appeal, it wouldn't really matter very much if you have to comply immediately, would it?
That's what makes it, well, if it were an interlocutory injunction that said that you didn't have to comply until final judgment was rendered, then it would, I guess maybe then it wouldn't be interlocutory. It would have been entered interlocutorily, but you wouldn't have to comply
That's correct.
until final judgment, and in that circumstance, would you be able to appeal or not?
I don't think so. It's if it's compelling action, and that's the lesson of Quest. If it compels action prior to final judgment, it's an appealable temporary injunction.
Any other questions? Thank you, Mr. Smith. We'll hear from the state.
Thank you, Mr. Chief Justice, and may it please the court. I'd like to focus my time this morning on the approach that the state advocates for, and then the reason why that matters for the state and some of these hypotheticals about why this type of order would be problematic when the state is involved. So starting with the former, in its response to the state's brief, Harley Marine concedes that the challenged order is an injunction. But Harley Marine appears to assert that it's somewhere in a gray zone between a temporary injunction and a permanent injunction. And this court has never recognized a category of injunction that's neither temporary nor permanent. Instead, as my colleague emphasized, the court's test is in Quest, just whether a trial court order places restrictions on a party and whether those restrictions apply before final judgment. And here, this order falls within that category. And to Justice Busby's question about temporary orders and sort of what's the limiting principle, I think the court can look to history. What types of orders have historically been subject to immediate appeal as temporary injunctions and which haven't. So, for example, in Walling, the court actually dealt with a temporary injunction that required specific performance. In Del Valle, it was an order requiring an election to be held under certain circumstances, and the court said that's an example of a mandatory temporary injunction. I'm not aware of any, but by contrast, discovery orders have never been understood to be something that's immediately appealable as a temporary injunction. So likewise, to the extent this court has never held that temporary orders in the family law context are appealable as temporary injunctions, I think the court can draw that line. Now, this straightforward approach matters to the state because of the state's ability to automatically supersede a temporary injunction by filing a notice of appeal. And so where the state wanted to get involved in this case, and our concern was that it might motivate a party to style their pleading a certain way in order to avoid that automatic supersedious effect when the state is a party. And I can just give a couple of examples. So obviously the state employs thousands of folks across the state at various agencies. And so the court might order, for example, reinstatement after a jury trial, which I don't think anyone disputes is a form of injunctive relief, but say, well, we're going to hold off on damages until we enter a final judgment. And so that is a form of mandatory injunctive relief.
The state hasn't been terribly shy about bringing mandamus petitions.
That's true, and we have had success, in large part in bringing mandamus petitions, and for the most part, that can be an avenue we pursue. I think that the problem is that in litigation where the state knows it's facing a temporary injunction, the state knows that part of that process is that if we're enjoined, we can file a notice of appeal and the injunction is superseded. And now we also know that the next step is that the party in the Court of Appeals might seek Rule 29.3 relief. But in advising our clients and the state deciding how to structure its actions in response to litigation, it matters that we know that certain steps are going to be followed. And one of those steps is that the injunction will be superseded upon the filing of a notice of appeal. And so to go through a mandamus, even though we might have success, it just causes a lot of confusion and potentially, as in this case, two separate appeals. I mean, I think.
Well, it might be difficult to prove that reinstating that there's no adequate remedy on appeal from reinstatement of an employee because you can just re-terminate them.
Right, I mean, there,
So mandamus may not be, that's a good example of when mandamus may not be available.
that's right, and I'm sure, we could think of other examples where mandamus just wouldn't be adequate to protect the party's interests, whereas, the other point I'd raise is, the interlocutory appeal statute, I think, recognizes that interlocutory injunctions are extraordinary remedies. And so, while those statutes are construed narrowly, there's a reason that the legislature provided a right to appeal. It's because when a court says you have to do something, immediately, and that's the difference between an order that maybe takes effect on final judgment versus an order that takes effect immediately. When a court says you need to do something, the legislature has said that is something that entitles you to a right to an immediate appeal, even though in the general course we prefer appeals after the final judgment. And so, in our view, there might be a reason that there was a temporary injunction that required this form of mandatory relief to require an immediate sale. The state's view is just that the party that was ordered to do that sale immediately has a right to appeal that instead of going through the mandamus process.
So if the court said you immediately need to turn over these documents, is that a temporary injunction that gives you a right to appeal?
No, I guess I'd have to know a little bit more, but if that's part of discovery, I think that that's a separate issue than something outside of court.
But it seems to fall within the scope of the rule that you articulated, and you would just say for historical reasons, we would just say don't go that far.
Yeah, I don't think the court would need to go that far. I mean, I think there's a big difference between turning over.
That doesn't seem very logically satisfying, though, if you're, as a way to craft a rule, if it sweeps in all these things that historically we've said aren't appealable.
Well, I think the order here falls within the historical definition of an injunction because, I mean, the court has said in Walling, and that was an example of specific performance. And I think there's a difference between specific performance and just an order requiring documents that sounds like it's just compliance with the rules of civil procedure.
Any other questions? Thank you, Mr. Abrams. We'll hear from the respondents.
May it please the court, Mr. Marino will present argument for the respondent.
Mr. Chief Justice, and may it please the court. My friends across the table are suggesting that we've somehow, this court has somehow, and its precedents has somehow repudiated the decision in Quest. And the reality is that the Court of Appeals in this case properly dismissed Channelview's appeal for lack of jurisdiction because the order appealed from was not a temporary injunction and therefore was not subject to interlocutory appeal under section 51014A4. I'd like to correct the record because it seemed the court had some considerable interest in mandamus and how mandamus might interact here. I'm sure my friend across the table is unaware of this. We moved to sever. We were not trying to delay. We wanted this to be immediately appealable. They opposed it successfully. On January 20th, 2022, our motion to sever was denied on their opposition. There is no doubt.
Because the requirements for severance weren't satisfied, given that the issues are still intertwined that are remaining in the case?
We wanted to sever because
right,
there
but
was
you don't
no,
have an automatic right to sever. The rules say
Sure.
you only get a severance under certain circumstances, and if the issues that are remaining are intertwined, then the court can deny your motion even if you want a severance.
Sure, well, that's undeniably so. But if you think about where we've been in the argument this morning, we heard that this order was irreversible, and that's the problem. I don't know how it would be irreversible.
Because the trial court could change its mind at any time before final judgment.
Well, if you think about it, the trial court could always change its mind in any case. There's no...
Not after they lose plenary power.
Well, there's no suggestion, Your Honor, that there was any intention or expectation that this would be anything other than final. There was a motion for reconsideration. That motion was denied.
Well, it's not final in the sense of final and appealable.
Well, it's interesting. If you look at section 51.014A, before it goes through the rather extensive laundry list that has grown over quite a bit of time of those matters that can be the subject of interlocutory appeal. The A says, a person may appeal from an interlocutory order of a district court, county court at law, statutory probate court, or county court that, and then goes through a laundry list. I believe what I'm hearing my friends across the table is saying is, just take the that out and just say, a person may appeal from an interlocutory order of a district court, county court at law, statutory probate court, or county court, period. And that's what they say at page 15 of their brief. They say every interlocutory order is temporary. That's not what the legislature said. What the legislature said was specific types of interlocutory orders are appealable. They don't want this court to confirm Quest. They want the court to repudiate Quest, and with it, Section 5104.014A4's narrow exception to the final judgment rule.
It seems that if you're right about how this works, then one concern would be that, parties who want what we would normally think of as temporary injunctions, and certainly the state might be a target of this kind of a thing, would just denominate what they're doing as partial summary judgment and seek it very early in the case, and then get it, and then the order granting it requires you to stop doing something that you're doing. Why would that not? Could we consider that a temporary injunction under your theory, or is the procedural denomination of it dispositive for you?
The procedural denomination is certainly not dispositive. What the court said in Quest was that the character and function of the order is what controls. And if you look at the cases that have been decided by the courts of appeals after Quest,
it's requiring you to do something now and you have that obligation, before final judgment. Like, what's the?
So I think the distinction is this: there's nothing temporary about an order that says you get summary judgment. This is not like the 1938 decision in Hume. It's not like the 1933 decision in DeBell. That's not what's going on here. This is a summary judgment. Whether the summary judgment procedure was even in effect at that time is unclear, but I will say this. What the court determined in this case was that there was no genuine issue of material fact and that we were entitled to judgment as a matter of law. They came back on reconsideration and the court said, no, we meant what we said. That's it, all right? They're telling you that these cases that are cited by the court at pages 7 and 8, okay, this is in their brief. They say at footnote 22 that the cases that the Court of Appeals relied upon were repudiated by Quest. Those cases, L Series, El Caballero Ranch, and Young, were decided long after Quest. And far from repudiating Quest, what they did was focus on the character and function. I don't think for a moment.
But one of the things they focused on in those cases, like in Young, is that there was not an order of execution or compliance with the court's judgment. And if that is the case, isn't it really more akin to a partial summary judgment? And I think what the other side is arguing is this order is different because it requires compliance with it during the pendency of the lawsuit. And what's your response to that?
Well, I think, Your Honor, when you get summary judgment, what has happened is the court has determined that there is not going to be a trial. There is no issues of fact. It's open and shut, right? That's the end of the story. They opposed summary judgment. They failed, right? So that's it. Now, in every case, the judge could have a change of mind, could see three ghosts and have a different thought, right? But what's really going on is it's over. That's not a temporary. What's the difference between that and the aloe vera line of cases? The aloe vera line of cases was all about elevating form over substance.
That sounds to me, the distinction that you're drawing there sounds to me like a procedural distinction rather than a real-world distinction from the perspective of the party that's on the receiving end of an order that they have to comply with before they can appeal it.
Well, here's the problem, Your Honor. They had many avenues that they chose not to pursue.
Could they have superseded the injunction?
I beg your pardon, Your Honor?
Could they have superseded the injunction?
They could have superseded the injunction. They didn't do that. They could have sought and won mandamus, and when they lost it, they could have appealed to this court. They didn't do that. Okay,
What rule would have allowed them to supersede the injunction?
Well, you're always in a position to supersede the injunction. Take a look at 51014D. They could have on their own motion. The rule says on a party's motion or on its own initiative, a trial court in a civil action may by written order permit an appeal from an order that is not otherwise appealable if the order to be appealed involves a controlling question of law, as to which there's a substantial ground for difference of opinion, which they have argued.
Yeah, and we've written a lot on that, and I understand about permissive appeals, but that's different from supersedious, which means they don't have to comply right now.
They could have posted a bond. They could have.
They did post a bond when there was the emergency relief provided to them.
Right, and then the court determined that mandamus was not appropriate.
Okay,
right?
so I thought that was when they were trying to get before the court got rid of the interlocutory appeal. Is that not correct?
They initially
posted the bond, and then the court said, no, you can't do it either which way. So that brings us right back to Justice Busby's question. Given that the Court of Appeals said you can't proceed to us in any form, how do they supersede or prevent the execution on that?
Well, they certainly could have, and I'm not clear as to why they could not have proceeded with the mandamus. And I certainly don't know.
You didn't oppose that? You didn't oppose mandamus relief?
We opposed mandamus release, but they did not. They
the
lost.
Reasons that you advanced presumably is why they couldn't proceed on it.
That's right. They lost, and they did not appeal that to this court.
Did the court in denying mandamus say, list the reason being that there was an adequate remedy by appeal?
Yes.
What is it?
If you, at the end of the case, if you lose, and they've lost, right? So let's say the rest of these issues that they did not want severed and opposed severance of are set aside, right? Now we're on appeal, and they win, then they get the property back.
If
you asked the question, is it
without liens, without any encumbrance, without any restrictions, you've sold it to somebody else, how do they get the property back?
Well, they have, their scenario, and they know this, they didn't choose to proceed in this way. But they know that they had the option to go with Section D. They didn't.
To seek a permissive appeal?
Strategic.
You know much about the history of permissive appeals in the Houston Courts of Appeals?
I do not, but I'm learning it.
I don't know if you answered Justice Young's question, because undoing a sale of real property is a big deal.
Yes.
And so you're just saying,
Sure.
oh, no big
Sure.
deal.
No, I wouldn't say no big deal, but I would say there's a difference between something requiring a lot of steps and a lot of procedures and being irreversible. That was my only point. I don't think it's irreversible.
In this case, do you dispute that, I mean, their point is, we're a single purpose entity here, and if we don't have our property, we don't have the income stream, we can't pay the mortgage, we're gone. So now you're gonna also reverse their bankruptcy and somehow claw back the property that you may have sold to another party because there's no encumbrance on the transfer that was ordered within 30 days. I don't understand how there's an adequate remedy by appeal. Please tell me more if there is.
I very greatly dispute the notion that they are in the situation they're describing. I probably have a bit too much personal knowledge of these parties because I've been involved in perhaps 6 different litigations with them in courts around the country, but to describe them as a single...
Well, just from our perspective of not knowing all of that,
entity,
we're just seeing this record as it comes. This is not the kind of circumstance in which a court would normally say, yeah, I think that this is probably not an adequate remedy by appeal.
Well, I think the reason they had an adequate remedy, and look, I guess what I'm pushing back against and I'm concerned about is the idea that this court would legislate and decide, you know, we don't like this situation, we're gonna fix this. We know that the legislature has said temporary injunction, and we're gonna call it something different, because let's be honest, it's temporary. A temporary injunction was the injunction in Quest temporary? Of course it was. It required them to do something quite specific on a continuing basis during the pendency of the
Is it not
lawsuit.
literally temporary in the sense that it was born but to die? When there's a final judgment, this injunction will not exist. There will be a final judgment that governs the relationship.
By that definition, and every single interlocutory order is temporary.
Well, that
Yes.
sounds right. Yeah.
But it's not right. the legislature
Which
said.
interlocutory orders do you think are final?
An interlocutory order that grants summary judgment.
I thought interlocutory and final were opposite
Sure,
words.
sure, but there's a difference between being a final order and being a temporary injunction. If the legislature had wanted to provide an appeal right in every circumstance in which there was an interlocutory order, like a summary judgment.
Not an interlocutory order, but an interlocutory temporary injunction.
Well, I mean, there's semantics at this point, right? Because
Not all orders are injunctions. You think that's semantic?
No, all orders are injunctions. All interlocutory orders are not temporary. And that's a distinction that the legislature drew. I don't think the legislature used the word temporary just as a sort of a throw-in.
What do you have to your friends on the other side who say that earlier in our legal history, and they quote some cases from appellate courts that say preliminary injunction, temporary injunction, interlocutory injunction, they're used synonymously. And so if we're looking backwards to when this language was added to our law, why would we not think, okay, that makes some sense? An
Because
interlocutory injunction is temporary in several different ways.
Because, Your Honor, that's not when it was added, right? They're back in the 30s, right? And they've gone and they produced an injunction from 1938. Here's what happens. These interlocutory orders begin to be appealed in 1895. That's where the first right comes in, right? The statute, this particular statute, is not drafted by the legislature until 1985, and it has gone through many iterations since then. But if you...
Well, turning to the statute and just leaving that aside for a second, the temporary injunction interlocutory appeal is different than many interlocutory appeals that the legislature has authorized because it allows the parties to proceed in the trial court. There's not an automatic stay of proceedings. So we've been talking about what they could do to preserve their appellate rights, but to the extent that it's critical for your client to convert this order into a final order, why hasn't the trial court proceeded with the underlying lawsuit and had a trial on the merits and resolved the claim for attorney's fees and offset and those kinds of things?
And as you might expect, having in the first place moved for severance and had them oppose it, and apparently they have lack of recollection, but they oppose it, and it was like, having done that, we also went to the trial court and said, when can we get a trial? And we were told by the clerk, it's not being reset because it's on appeal. That's why. I mean, you think we don't want this to happen? Like pronto, we want it to happen immediately.
That's a kind of a change in mindset among trial judges.
I understand.
Who used to want to get the case resolved as quickly as they could to moot the temporary order.
At the risk of offending any of my friends on the trial court, right.
I think it's perfectly reasonable.
It's fine.
But you've asked for the trial setting is what you said.
Yes, we've asked for the trial setting. We're told it's not going to be reset because it's on appeal. We tried to sever, that didn't work. They tried to get mandamus, but they didn't follow through on it completely. I understand there's different
So
standards.
you say, you've told us, and I believe you want this done, but perhaps in part because of the stay imposed by this court. Why resist so heavily then? Is it just that you're just being an honest friend of the court and you just want to save us from the terrible mistake of expanding our interlocutory appeals? Why not just say, yeah, that sounds great, let's have this appeal?
Because I want the benefit of the order that I want.
Yeah,
I'm a true friend of the court, but I'm a better friend of the client.
I see, so it's actually not.
Amicus clientis.
Right. All right.
I've been sitting there trying to figure that out too. So I get, and I'm really kind of sympathetic to
Appreciate
your
the candor.
argument that temporary and interlocutory are not synonymous terms, and that the petitioner essentially argues that it is, but if that were true, you wouldn't need the subsections of 014A. You'd just say it's interlocutory and therefore it's temporary, and I get all that. It makes sense. And then I'm sitting here thinking, okay, but then why does it matter? Because it can only matter if, I was thinking, it only matters because you want to deprive them of the right to stop this sale from happening through appellate review of some sort, and I don't think that's right. I think you agree that they ought to have the right to have some appellate review of this permanent decision, right? Interlocutory permanent decision. And so then it occurs to me, what it is you just want it to be clear in the trial court, we're done with this.
Yeah.
We don't have to go try this again
Right.
for a final trial. That's what's important to you.
That's 100% right. And let me just say this. Our behavior in this case is totally reflective of
Because
that.
if it's a temporary injunction in the truest sense as you would want to use it, we may have decided on the court may have decided on January 1 that for now you get this, but I haven't decided yet whether you really get it. That's yet to be tried. And you want to make it clear, this is not yet to be tried. It's done, right? That's what matters to you?
Every single case, they say these are cases that were repudiated by Quest. These are cases that followed Quest first. We're talking about L Series, El Caballero Ranch, and Young. If you look at those cases, they make all the sense in the world. So there's no confusion. We're not going back to a formulaic approach of aloe vera. We're talking about, it's styled a permanent injunction. That's not what this is about. It's about character and function. And what's the character and function of a summary judgment? I won. You know why I won? Because I had an order that said I get to buy the property for $2.5 million. It's not my fault.
You don't dispute that they're entitled to some appellate review of that decision.
Sure, I wanted them to
before
have
they have to give you the property.
I wanted them to have it.
Yeah.
You wanted them to have it before you didn't want them to have it.
Yeah. I know, I wanted them to have it, right? Before they didn't want to have it. I wanted severance. They didn't want severance. I wanted to say, let's go forward. These are what we call attorney-client claims.
Even if you both want severance, the trial court can't give it to you if the rules don't allow it.
I got that part, but to say the rules don't allow it, I think is incorrect.
Well, I may disagree with you on that.
I understand,
but that's not what's in front of us. Let me ask you this. Wouldn't you be better off financially if this were an interlocutory appeal instead of mandamus? Because then they would have to post a bond to supersede the injunction while they were appealing it, whereas with mandamus, they can just get an emergency order staying it. And then at least you'd have the bond to compensate you for any delay.
The problem is this. I want the property. I'm entitled to the property. That's what the contract says.
Well, but under what your discussion with Justice Boyd, you say you want them to have appellate review before you get the property. So wouldn't you rather have a bond while that's happening than no bond?
Justice Busby, it's great fun interacting with you. And I will tell you this. I believe to the core of my being that I tried to get them their appellate review when they didn't want it, okay? I want the property. If they agreed to sever the claims, which I'm sure they're going to be asked, why not? I'm sure they're going to be asked, what about that business that he told us that, you were wrong about the thing? Why not? Sever the claims. You know what the claims are for? Attorney fees and offset of the option payment. Let's do it. Let's just go. I want to do it. They don't want to do it. If we did that, they would have had their appellate review. I think they would have not prevailed. But look, if you were to reverse what the Court of Appeals did here, I think you're repudiating Quest. Look at L Series and El Caballero Ranch and Young, all those. They don't talk about Hickson, they don't talk about In re Robinson family, or all those cases that were decided after Quest that actually allowed a temporary injunction, said this is temporary injunction, let it be appealed. They don't talk about those cases. Things are working just fine. No one is back to aloe vera. That's nonsense. And these 30s cases, respectfully, they predate the statute that governs here. This statute is clear. It couldn't be clearer. It says you can have an appeal of an interlocutory order when boom, boom, boom. They want all the boom, boom, boom out of there. They want it just to be, you can always do it. They're all temporary.
Any other questions?
Thank you very much, Your Honor.
Thank you, Mr. Boyle. Mr. Gunn, you have 5 minutes.
Is your argument contingent on the court's recognition that temporary and interlocutory are completely synonymous?
They feel synonymous to me, and they feel.
So then why have
same thing.
A4? Why not just have A?
It's product of history. We had 100 years of the statute being amended, and you had the 1895 statutes, 1907. You can appeal a temporary injunction. The 1925 revision, We finally get them put into a code. Why it's in the Civil Practice and Remedies Code instead of the Government Code, nobody knows, but that's where it is.
Well, not
And
all
it has
orders
grown
are,
over time.
not all orders are injunctions.
Exactly right.
So the top of the statute is about orders,
Sure.
and then an injunction is the thing that you can appeal.
It is,
But with regard to injunctions, you could, what if you had a multi-party case and the court enters a final injunction against party A, but there are still other parties, so the judgment's not final?
Right.
Is that interlocutory or temporary or permanent or final?
it sounds interlocutory and sounds appealable if it's an injunction, right then. Can I give you a case to go read that's not in our briefs that's responsive to this line of questions? It's called Whatley against King from 1952. Whatley, 249 Southwest 2nd, 57. It is like Quest and Del Valle because you had a court of appeals saying, I can't review this, there's something left, and this hypo came up. Here's final disposition saying thou shalt convey whatever this property is to the other side, but there's another issue left. That was Whatley. And the Court of Appeals said, I can't touch that. And this court said 8-1, of course you can. That's an injunction.
So it makes a lot of sense that we wouldn't want the procedural denomination of the injunction to be determining whether you get to appeal it, but once you're appealing it, the procedural denomination of the injunction might affect the way that appellate review is conducted, maybe or maybe not, right? So like for a temporary injunction, you're looking for probable right to relief and you're balancing the equities, and we know that standard. If you're reviewing on appeal a summary judgment, you're in sort of a different land of these are the standards and here's what we're doing. And so which one would be applied in a case like this?
Absolutely. It's going to depend on the order. I'm really glad you asked that because I want to ask you, hold that order means order. It's the whole order, whatever's in it. Maybe it's just the injunctive order, but maybe it also has the summary judgment in there. And maybe it has some third thing. However many items are in the four corners of that document, that's the order. Justice Devine's opinion in Elephant sort of makes that point. Judge Lamron, your opinion in D Magazine makes that point. I think it's being missed. And what we're going to see, kind of like what we talked about, have you tried a permissive appeal in the Houston courts? What you're going to see systemically is courts of appeals saying, okay, I have this order. Oh, I see an injunction. I can review that, but nothing else. I'm not going to look at anything else in the other paragraphs. And that's a big problem.
Even if it's just the order, just the injunctive part of it that's appealable, it's still been granted after the court saying there's no material fact issues and you're entitled to this as a matter of law, as opposed to a TI which is granted based on a probable right to relief and other considerations. So which does the appellate court, which of those areas, those lines of appellate review does the appellate court apply to an order like this?
I said you take the order, you review everything in it. If there's a summary judgment, that's reviewable. Brailsford said, oh no, we can't do that. It's a summary judgment injunction. And I think you were trying to say politely that Brailsford is wrong when you wrote Quest, but I think it needs to be more definitive. Brailsford is fruit of the poisonous aloe vera, and you need to address aloe vera once and for all. And if the court chooses to say no, aloe vera is fine, so be it. But I'm here to say, just as a practitioner, mandamus is so far inferior. I mean, it's worse than permissive appeal. And it's worse for you. You get no reasons half the time in mandamus. You just get denied. And you don't know what it means. You will be happier in the long run with better oversight of the lower courts if you say, no, these should not be off limits just because there's something, there's a summary judgment involved. Make it where it's reviewable by appeal, like it has been, in our view, for almost a century, at least since 1933. And we think Whatley is consistent, Quest and Del Valle are consistent. There should not be a pocket where if the temporary injunction becomes turbocharged, now it's off limits and we've got these catastrophic problems. Mandamus is a bad
Would y'all need to post a
remedy.
bond if it were an interlocutory appeal of a TI? I can't remember. I can go back and look at the rules, but is there a bond on the file here?
My memory is that would be discretionary, and I'm not crazy about getting into a discretionary problem. And you're right, mandamus, maybe we ask for a stay, but again, those rules I think would be comparable. So we may have to go have an argument with a trial judge. What's the status quo going to be? And if that fails, we got to go to the Court of Appeals. But at least we can start the process if we can appeal it and get some review. Because right now we're in the situation where We take up an appeal, and the court says, no, you can't appeal that. And we take up a mandamus, and they said, no, you have an adequate remedy by appeal. I'm like, well, something's wrong with this picture. And I think it should be appealable.
If we rule for you, do you foresee a risk that we'll see a surge in attempted appeals from TROs?
No, not from TROs. I see almost none of those in my practice. They happen so quickly. We're talking a week or two, and then you get the hearing. I would not consider the risk bad if people are actually seeking review and have a colorable argument for it. The history of the last century is we need more appellate guidance, not less. And I'm glad I can finish my argument without being asked about family law, because my goal is to get through my whole career without having to talk about it. I'm sure there's an answer. I would say the federal definition of injunction from Wright and Miller that we've given you is probably the best way to deal with that. But please don't ask me a follow-up.
Any other questions? Thank you, Mr.
Thank you.
Gunn. Case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.